Hi, welcome to another Title Talk. Today we're talking about buyers that cancel during the inspection periods and when do sellers not have to give the deposit back. Hi, I'm Jim Brown. I'm an attorney at James Brown Law, Florida real estate law firm, and founder at New Path Title. We've all seen it before. We have a great looking deal, cash, no contingencies, and the buyer cancels in the last seconds of the transaction for no apparent reason. There are 2 points I'd like to make in this title talk. One, can a buyer cancel for any reason? And two, does a seller have the duty to give the deposit back just because a buyer canceled? On the first issue, almost all the realtors I talk to know that a buyer can cancel for any reason. I do, however, talk to some realtors that insist a buyer has to have justification for the cancellation, some physical defect in the property or something, and that's just not the case. So I'm not going to belabor that point. The second issue I want to make is, does the seller have to give the deposit back? So the facts of this transaction are kind of interesting. It was a $3.5 million sale. The deposit was $750,000. The inspection period was relatively long. The closing period after the inspections was very short. The seller wanted a lot of security, and the property was septic. It had a huge driveway, and many features of the house were very expensive. So what happens is, and the seller was away for a month in Europe. The issue is the buyer canceled in the last minutes of the inspection period, and the seller refused to give the deposit back, and everybody was coming unglued, and the buyer had actually found another property, and they thought they could cancel right away and slide the deposits, which were huge, into the new property, and the seller said, no, I'm not giving you back your deposits. Attorneys were engaged, we were engaged, and everybody got wild and heated up. The answer is, does the seller have to give the deposit back? The question is, and the answer is no. And the answer is on line 267 of the 1021 FAR as is, which says that the seller is under a duty to sign the release basically and get it back to the buyer in a prompt and reasonable amount of time unless there's damage to the property. So in this particular transaction, the facts we talked about, very expensive property, huge driveway, septic system. The septic tank engineer showed up in one of those big septic tank evacuation trucks, broke the driveway. The driveway was a gigantic monolithic pour and would be very expensive to tear out. The sellers were in Europe. That would not allow them to get estimates, and so it would take some time, and buyers' plan to cancel this and jump into their new contract was spoiled. Everybody was upset, but the seller was 100% justified in not signing the cancellation immediately. And that rule is a rule I go over with many realtors, and I can't tell you how many don't know that that rule exists. So if you have problems in a transaction, you want to call me, I'll give you my text number. You can 24/7 get a hold of me. And I look forward to seeing you guys in the next Title Talk. Don't forget to like and subscribe. Be good.